All right. Welcome to our officially first panel. And the first thing I do want to do is go ahead and introduce our panel participants. We have Christine Fox, the Circuit Case Budgeting Attorney for the Ninth Circuit, Bob Rand, Circuit Case Budgeting Attorney for the Sixth Circuit, Peter Shaw, Appellate Commissioner from the Ninth Circuit, Jerry Tritz, Circuit Case Budgeting Attorney from the Second Circuit, and Diana Weiss, CJA Attorney from the Northern District of California. Before we get started, let me say, as you can probably tell, we're running a little bit over schedule, but it is really important. You've taken the time to be here. We want to hear from you. And so if we have to eat a little bit into the lunch hour, I will make that call. So feel free, we need to hear from you, and that's really important to us. The way we're going to operate this is we've gotten your submissions and we've had the opportunity to look through those. So as we begin, you do not need to read those or reiterate those. What I'd like you to do is make sort of a brief opening statement, and then we're going to get right into the questioning. So we'll start with you, Ms. Fox.
Thank you, Judge. And taking that to heart, these will be very brief. Good morning. Thank you for inviting me to participate in these very important hearings. I know you are grappling with many different issues, and I do not envy your task. You have my written submissions, as you said, so I will limit my remarks to just some brief comments about budgeting. Since I began working at the Ninth Circuit as one of two case budgeting attorneys, I have been asked by numerous times by both judges and panel attorneys, why budget? Well, the answer to me is threefold. Budgeting benefits the court, it benefits counsel, and more importantly, it benefits the defendant. So when we budget a case, we work directly with appointed counsel, serving as a type of mediator between counsel and the court. This saves the court time by reducing the need for ex parte hearings and the filing of numerous individual funding requests. It also removes what I like to call the sticker shock that some judges feel when extraordinarily large vouchers are submitted at the end of a case. And it generally makes voucher review easier. So long as counsel's build time is within the budget, a voucher is much more likely to be found reasonable and, absent any technical problems, paid in full. From counsel's perspective, budgeting leads to better case management and consequently higher quality representation because the act of preparing a budget gets counsel to think through the case and plan ahead at an earlier stage of the litigation. And in multi-defendant cases, budgeting gets counsel to think about collaboration on tasks that do not involve conflict, such as investigating informants or organizing discovery or preparing joint motions. Having a budget also provides some assurances that vouchers will be processed in a timely manner and will likely be approved. All of this benefits the defendant. And I have seen during some of your previous hearings questions about the underutilization of service providers by panel attorneys. And you probably are already aware, but in 2010, the FJC conducted a study of the Circuit Budgeting Attorney Program, and they concluded that budgeted cases have an increased use of service providers and of more different types of providers than non-budgeted cases. This, again, benefits the defendant by improving the quality of representation. So thank you again for inviting me, and I look forward to answering your questions to the best of my ability.
Thank you. Mr. Rand.
Thank you, Judge. Good morning. Again, I would like to echo Christine in thanking you for the opportunity to appear here. I'm just going to have a few brief opening statements, and they might sound a little scattered because I'm assuming you all will zero in on whatever questions you're interested in. We are, as case budgeting attorneys, in effect, as my colleague Mr. Tritz always likes to say, we're one person trying to work with a 300 to 400 attorney law firm, which is the CJA panels in our community. At the same time, we in effect serve many masters. All of our judges throughout the circuit and districts are unique individuals with their own background, their own ideas, and their own areas of expertise and what they've dealt with in the past. So we do, in effect, become, in a sense, mediators between the attorneys and the judges in many cases. I would like to point out, maybe I should have prefaced with this, What I'm planning on talking about today, I would like you to take as my own personal opinions. I don't feel I have the authority, or should I be speaking for all of the 9 case budgeting attorneys as a whole. We are actually having a meeting tomorrow, and I'm sure we'll discuss much of what goes on today. But in my opinion, CJA attorneys are in effect second-class citizens in our justice system. The prosecutors don't have to come in and beg for resources. They don't have to divulge their trial strategy to a judge in order to ask for resources or experts that they might need. They don't, AUSA does not have to justify everything they do. And I would venture a guess that to the best of my knowledge, AUSAs have never been told, prosecute this case as cheaply as you can, which is, although it might not be as blunt as that, that is pretty much what a CJA attorney is given to understand, that, you better not go crazy on how much you spend on a case. That's a big portion of what we do, is trying to get the resources for the CJA attorneys that they both need and deserve. Also, through that same vein, CJA attorneys and case budgeting attorneys, much of what we do is in response to what is done by the AUSA. As I know has been talked about quite a bit at these hearings, in today's world with computers, websites, now we're running into, Facebook, tweets, and I'm an old guy, I'm not even up to date on a lot of that stuff, but that's all included in much discovery now. You can't speed read audio, you can't speed read videotapes, poll cameras, and we have so many cases now where there's hundreds of hours of those sort of things. Some specific cost savings that I would recommend, and I talked about this in my submission very briefly, some sort of copy center, whether it be in the courthouse or whatever, make 1 or 2 copy machines available to CJA attorneys to run their copies for their cases, for their appeals, as opposed to farming those out to individual contractors. We spend a huge amount of money copying discovery in effect, copying CDs, DVDs. A law firm doesn't farm that sort of thing out. They have their own centers for it. Making an IT person available to the CJA to help them assist with the electronic discovery. Sean Broderick's office does a wonderful job, but again, Sean has a small office and they're dealing with what I think he said 10,000 CJA panel attorneys. I would suggest we need some sort of mid-level managers, in effect, almost a new system where, whether it be in each district or perhaps shared in districts, who would be a mid-level manager for the CJA attorneys. Perhaps that person could be the one who makes the decision on whether or not resources should be made available to the attorney. Take that away from the judge. Take away that having to divulge trial strategy to a judge who, in my opinion, in many cases would rather not deal with that issue. As far as who should review vouchers, again, I don't presume to tell this committee what to do. I know many of my judges aren't thrilled about reviewing vouchers, and I think would be happy to pass that off. The issue I've run into throughout my own circuit, and it's not super prevalent, but it has happened, is non-attorneys who are reviewing attorney vouchers. I have a real problem with that as a former criminal defense attorney. Again, it would be like, I don't presume to tell a neurosurgeon how to do his surgery. For the same reason, should somebody in the clerk's office or in one of my districts, should a judicial assistant be the one who is reviewing vouchers and telling an attorney that this is not reasonable, you should not be charging for this. So I think we need objective people to do that, but it should definitely, in all cases, I believe, be an attorney who is the one reviewing vouchers and making a decision on whether or not resources should be available. Again, these are all my own individual opinions. Again, in response to one of I think it was the Birmingham possibly thing, I have reviewed quite a bit of that, and I heard one individual say that they felt that the $129 per hour for a CJA attorney was reasonable, and the reference was made that, well, that probably comes out to as much or maybe even a little more than a prosecutor gets paid. On that, I would just like to point out that a prosecutor and even a federal defender are on salary. They get paid for 40 hours a week. A CJA attorney, that $129 is per billable hour. They don't get paid 40 hours per week. I think it's been shown fairly clearly in all the studies that the overhead comes to a big chunk of that $129 per hour. So I don't agree that the $129 per hour is a reasonable fee. And then the final thing I would like to say, and Judge Moskowitz, I think, did a wonderful job in referencing this. The same thing applies to the case budgeting attorneys and to whatever suggestions you might come up with as to how to maybe revamp the CJA. Don't get caught in the one-size-fits-all mindset. Even among the case budgeting attorneys, one size does not fit all. Every circuit has its own needs. Every circuit has its own culture and its own policies. And in fact, to go even further, even within a circuit, every district has its own needs and policies. Where Mr. Tritz and I saw the need and were able to fill the need to review excess compensation vouchers in the Ninth Circuit, for instance, Christine and Blair being two case budgeting attorneys, it would literally be physically impossible for them to try and review every excess comp voucher in that circuit. So we need a framework, but we don't need a one-size-fits-all. Thank you.
Shaw.
Thank you, Judge Cardone, and other distinguished members of the committee. I wanted to tell you about the Ninth Circuit's approach to CJA management, and that is through the use of the appellate commissioner position. A bit about the creation of the position. The Ninth Circuit historically was facing vastly increased workloads with no concomitant increase in the number of judgeships. And as a result, the court decided to explore the possibility of creating a magistrate-level position in the Court of Appeals to handle properly delegable judicial functions, one of which is a ruling on all CJA appellate vouchers. So in 1994, the court created the position of appellate commissioner and delegated a number of responsibilities that judges had formerly performed to the appellate commissioner. The court authorized the commissioner to rule on a wide variety of motions, many of which involve practice by appointed counsel on appeal. Motions for appointment, substitution, or withdrawal of counsel, motions for leave to proceed in forma pauperis, for extensions of brief length, for extensions of time, motions to seal and unseal, and the like. The court also referred a number of other matters to the appellate commissioner. It referred to the commissioner the responsibility to rule on awards of fees in civil cases, which has informed me as well in my evaluation of Criminal Justice Act vouchers. I also conduct hearings and prepare reports and recommendations in National Labor Relations Board enforcement proceedings and other contempt proceedings in the court. I conduct hearings and issue reports and recommendations in requests for self-representation on appeal, the appellate equivalent of the Feretta hearing that's performed in the district court. And I also manage generally in the court quality of practice issues and attorney discipline, and I conduct disciplinary hearings and issue reports and recommendations when an attorney may be subject to suspension or disbarment from the bar of the Ninth Circuit. In complex cases, the mega cases that you're inquiring about today, I conduct case management conferences. I'll discuss that a little bit in a moment. And then I also handle all the CJA management responsibilities, including panel composition issues, selection and training, as well as making the initial ruling on all appellate vouchers. The former practice the court had was to assign vouchers to individual judges, typically the lead judge on a merits panel, a 3-judge panel, and that process of distributing this workload was unpopular. It was unpopular with judges, it was unpopular with attorneys. Judges often felt unprepared to make compensation decisions, as Judge Moskowitz pointed out a little while ago. They often, I think, believed that the decision-making process was one that was administrative, that they had not been trained to do, and that fell outside the judicial function for which they were appointed. And as the committee has heard in other hearings, there is considerable debate whether the judges who make merits determinations are in an appropriate position also to make compensation determinations. Having multiple judges assigned with the task of making compensation rulings also led to inconsistency, slow payment, and reductions without explanations. This resulted in numerous complaints from appointed counsel in the circuit, and that stack of complaints that was handed to me when I stepped into my chambers for the first time was probably one of the most important reasons that the court actually went ahead and created the position. Having a single decision maker make the initial decisions on all appellate vouchers solved these problems. In terms of uniformity, when I first started 22 years ago, I took a look at all the criteria that make an appeal complex or simple and tried to identify a snapshot of the case, what to guide me as I looked at the vouchers. And seeing all the vouchers from all the practitioners in the circuit gave me a database from which to draw to see what was the range of reasonable work. I had also spent 7 years in private practice, most of which had been as an appellate litigator, so I had done this kind of work, and I knew what it meant to review a record and to prepare a brief, and to prepare for oral argument. I also made prompt review and compensation a high priority, so vouchers don't linger with me for months. I try and pay these attorneys, they work. As was just pointed out, they're not salaried. They rely on getting paid in order to support themselves and their families, and I try and do that. When I see a voucher that I believe is excessive, I will give notice to the attorney. I'll give a detailed explanation why I believe that the matter is excessive, and I'll give the attorney an opportunity to comment before I make a reduction. And I take those comments seriously, and sometimes I change my mind based upon what they tell me. Having the decision made by an officer who is uninvolved in the merits determination allowed for an objective view of the reasonableness of the time expended in perfecting the appeal. The decision maker, the judge who rules on the merits, may find the case very simple at the decision-making time, and not appreciate the fact that the attorney reasonably had to go through a lot of steps to get to that stage, and really needed to cross T's and dot I's on the way there. In terms of panel management, in our circuit, each district has its own CJA plan with its own CJA panel, and almost all of them have separate appellate panels. I work with those appointing authorities in each of the districts in selecting, training, and evaluating the appellate panel attorneys. I often travel throughout the circuit and give talks about Ninth Circuit practice and procedure, about my approach to compensation issues and the like. And the goal of all this is to ensure high quality and efficient appellate representation. And I wanted to make a separate point to you about a matter that I'm not sure has come to the forefront of the committee's attention, and that is the question of continuity of representation. Most circuits have a rule that specifies that trial counsel will keep the case on appeal. And 10 years ago, the Vera Institute was looking into this question, and I wanted to report to you from my own experience doing this for 22 years, I am a staunch advocate of appellate specialization. I endorse an approach where trial court counsel can easily come off cases, no question asked, and be replaced by an appellate specialist. My experience is that appellate specialists generally provide much higher quality representation and do so at no significant additional expense. Any possible gain that you would conceive of by a trial court attorney being already familiar with the record and getting a cost savings that way is almost always overcome by the familiarity of the appellate attorney in researching, writing, knowing how to look at a record with an eye to evaluating the case in the same way that the judges will, who ultimately will decide the case. Case budgeting and mega cases, which is the prime topic in your agenda today. I, as I mentioned, conduct case management conferences in complex multi-party cases. The goals of those conferences are two. First, case management, trying to address issues common to all the parties. So the government attorney and all defense counsel participate. We talk about consolidation, transcript production, briefing schedules, and all with the goal of avoiding unnecessary motions practice and allowing the parties to navigate the appellate process as efficiently as possible, both for them and for the court. I then excuse the government counsel, and we proceed with the second part of the conference with just counsel for the defendants, usually all of whom are appointed. And it's in this section where we explore ways in which the appeals can proceed efficiently. How can we efficiently produce briefs and records? Might it be cost effective to appoint a paralegal assistant to summarize a transcript of a months-long trial and make that transcript summary available to all counsel for all co-defendants? And then I have the great benefit of having two circuit case budgeting attorneys, one of which is my distinguished colleague on the panel here today, Christine, and I then ask the attorneys to work with the case budgeting attorneys to come up with a budget, a realistic budget that will take into account what they need to do. And these attorneys who are in these complex cases are often attorneys who have been handpicked. They're experienced appellate specialists who know how to handle this kind of case. And they prepare a budget, I take a look at it and I approve it, or I revise it and approve it, and that facilitates the quick approval of interim vouchers. So these are the kind of cases that may take 6 months or 8 months before there's any work product. And ordinarily, in a non-complex case, I prefer not to give interim vouchers until the opening brief is filed. And that usually is just a matter of a couple of months or so. And at that time, I can evaluate the performance. But in these cases, it's really unfair to make the attorneys wait for those many months while they're reviewing the record and consulting with each other and drafting the brief. So in those cases, once we have a budget, I feel very comfortable in approving interim payments as we go along, so long as it doesn't exceed the budget. And I think we're now doing 2-stage budgets, one for the record review process and then one for the briefing process. So many circuits have delegated the compensation function to a staff member. I'm now addressing the appellate courts in particular, and that achieves many of the advantages I've discussed in terms of uniformity and the like. But I think that our circuit has found significant benefits in creating this magistrate level position and delegating these additional functions. There's a synergistic effect when a single person sees not only the vouchers and briefs submitted by appointed counsel, but also evaluates and rules on those attorneys' motions for extension of time, motions for leave to file oversized briefs to see if the attorney is really pinpointing the issues, looks at responses to orders to show cause, observes their presentations at case budgeting conferences, and more. Also, because I do an overall quality of practice review, I get feedback from judges and staff on attorney performance, and particularly when attorneys are underperforming. And that allows me to evaluate the quality of practitioners. All this not only aids in the compensation decision, but it also aids in the important decision whether an attorney is serving the clients in the court at a level expected of an attorney that the government selects and appoints to represent counsel. There's also a valuable effect when I also, in addition to doing all these things, get to go and travel around and meet with the attorneys, the appellate panel attorneys in seminars, and get feedback from them and give them information that will enable them to be better practitioners. So I guess, in sum, having a qualified magistrate level officer handling this bundle of functions offers a degree of credibility, stature, and respect to the attorneys who serve on appellate panels, to their clients, to the courts, and to the administration of justice. Thank you.
Right. Mr. Tritz.
Good morning. My name is Jerry Tritz, and I'm the case budgeting attorney for the Second Circuit. I was one of the first 3 case budgeting attorneys hired, and I participated in the pilot program, which led to case budgeting becoming a national program. When I was interviewed for the CBA position, I told the search committee that, in my view, if the circuit was truly interested in conserving costs, 2 things had to happen. First, our panel members had to be made to realize that there was more to being a CJA panel member than merely putting your name on a list. That with membership came the responsibility to provide quality representation in a responsible and cost-effective way. The second point I made with the search committee was that if the circuit was truly interested in conserving costs, they'd have to come to grips with the fact that, like it or not, the circuit was running a 400-man law firm called the Second Circuit CJA panel, and they should start acting like it. Case budgeting has been a tool we use to accomplish the first goal. Case budgeting has been instrumental in changing the culture of our panel in the Second Circuit to one that accepts that along with membership comes the obligation to contain costs, to be accountable, and to be fiscally responsible. Case budgeting in capital and mega cases forces our lawyers to examine their case, decide where their case is going, and how they're going to get there. Once this has been done, we encourage the lawyers to employ presumptive rates and of compensation where applicable, and to use best practices when retaining expert service providers. Presumptive rates assure that everyone is paid the same rate for the same work. All mitigation people get $100 an hour. All investigators get the same rate of compensation. Best practices is nothing more than commonly accepted business practices which could be found in any law firm in the nation who is conscious of their obligation to provide quality representation to their clients in a cost-effective way. I've given examples of this in my written statement and will not repeat them here, beyond pointing out that what I'm talking about is such things as negotiating a lower price, using lower-cost associates and paralegals where appropriate. These concepts have been embraced by our panel because it's in their best interest to do so. Utilizing presumptive rates and best practices and making the presiding judge aware of these efforts, they have learned that they are far more likely to get favorable rulings from the court when they use these principles. The first prong of this 2-prong approach is in place in the Second Circuit, so let me turn to the second prong, which is acceptance by the circuit of the reality that they're running a law firm. I believe this is an area where substantial improvement can be had. But that is not to say that the judiciary has not been doing an excellent job for the past 50 years in running the program. But the truth is, in my view, there is room for improvement. And just as the panel has accepted case budgeting because it's in their best interest, I believe the circuit should accept the idea that someone should be in charge because it's there in the court's best interest to do so as well. Now, why do I say that? Because the perception is that some judges unreasonably cut vouchers. The perception is that what you are paid may be more of a reflection of who your judge is rather than the work you performed. The perception is that to agree to a reduction is the equivalent that you did something wrong. The presumption is that making a written submission is picking a fight with the judge. The presumption is to make a prior authorization request forces you to reveal information to the court which may jump up and bite your client at sentencing. The perception is that no two judges handle vouchers or any of the other things related to the CJA program exactly the same. The presumption is that judges get no training before they take the bench on CJA matters. They may have no criminal trial experience in their background, and they have maybe never represented a criminal client, but yet they are called upon to make decisions which will affect the quality of representation of the CJA clients. I think this could all these issues could be eliminated if an experienced professional were placed in charge of the panel and given approval authority, approval to approve budgets, approval to approve service providers, approval to approve vouchers. This would create transparency, consistency, and insulate the court from the appearance of conflicts of interest that naturally flow when this is not done. I want to conclude by thanking the committee for the opportunity to appear before you today and to share my thoughts. Thank you very much.
Thank you. And Ms. Weiss.
Good morning, Judge Cordone and committee members. Welcome to the Northern District of California. We're happy that you're here. Thank you for the opportunity to testify this morning and for all of your hard work in this long overdue study of the Criminal Justice Act. I will not repeat my remarks contained in my written submission. However, I do believe that there are several issues that should be repeated, and those are in regard to the structures put in place by the Criminal Justice Act plan in our district. They are ones that serve the panel as well as the judiciary well. Our structure addresses many of the issues that have been raised in other districts as problems, and I believe that there are particularly issues with respect to panel selection and funding of ancillary services. I believe our plan is successful because the court, the panel, and the federal defenders all have input into the process. We all have a stake in the outcome, and we all meet and discuss issues that arise. This is true with respect to the panel selection, with respect to a fee review committee, as well as administrative issues as they arise. Working together fosters a culture of transparency, collaboration, trust, and mutual respect. Appointments in our district are done on a strict rotational basis. Our panel members are highly vetted, and it is an honor and a privilege for the lawyers to be on our panel. We are happy to have them. We feel in the court that it is an honor and a privilege to have them practice before us. As a result, the lawyers, we have some of the best lawyers in the country on our panel. Lastly, I want to discuss my position as a CJA supervising attorney. I was a panel member for over 10 years, and I've been working on CJA cases in this district for almost 30 years prior to taking this position. I know the judges who I practiced before, who I'm now working with, as well as the panel members. My position differs from other folks who are holding the same title in other districts for several reasons, including the fact that voucher review and funding requests are delegated to me for approval by the court. I do a reasonableness review of the vouchers. Having an experienced federal practitioner and a former member of the panel gives both the court and the panel confidence that there will be a fair and reasonable review of vouchers. Additionally, with respect to funding requests and other service providers, I make some of them, the routine ones, I am delegated authority to approve, and other ones I vet and make a recommendation to the court. This structure places me in the position of an intermediary, which removes many of the issues that folks have talked about before, giving the trial judge, the structure basically sets up the system where I could have frank and open discussions with the panel members regarding what do they really need, what are the costs associated, what are the justifications for their requests, without the fear of becoming an adversary with the trial court judge. I then also have these open discussions with the judges so that they can understand and be educated as to what really needs to be done, and with a healthy respect for the defense function. This process helps to ensure that costs are contained, attorneys receive adequate funding for their service providers, and most importantly, that indigent defendants receive effective and zealous representation in our district. I look forward to answering your questions, and thank you again for inviting me.
All right, let's start with Mr. Frensley.
Thank you. So, obviously, one of the things we're looking at are alternatives, and a number of you spoke about today in your remarks and also in your written presentations about alternatives. And I guess I'll direct my question first to Mr. Rands and Mr. Tritz with respect to the role that you play in the circuit with respect to reviewing excess compensation vouchers. And I'd ask you to start with the issue about, obviously, there's a statutory requirement that excess vouchers go to the circuit. Do you think that that is necessary? Do you think it's appropriate? Do you think that there's anything magic about the circuit judge's position, whoever the designee is, that makes them well equipped to consider excess vouchers? And finally, do you think that someone in your capacity, given the role that you have, would be just as capable and just as adequate as being the final decision maker on excess voucher issues? Bob, if you want to start, that's fine.
Okay, thanks, Jim. Again, I'm speaking for myself.
Sure.
I do not think that it's necessary for the vouchers to come to the circuit. In some cases, I feel that it's almost counterproductive in that obviously the district court judge, and in budgeted cases myself, know a lot more about the case than a circuit judge who quite frankly knows nothing about the case, which is why, at least in our circuit, as you know, we have the requirement that the district court judge is supposed to send a letter to the circuit court judge on every excess compensation voucher regarding their feeling about it, and that they're familiar with the case and that they're recommending approval of that voucher. That being said, again, I'm not trying to take on more authority than I should have or to be self-aggrandizing here, but I do think the case budgeting attorney role, and specifically what Jerry and I do, is very important to the circuit, and I'm proud of the whole program. I think we've taken the weight off of the shoulders of the judges, and after, well, I guess next month will be the conclusion of my 9th year, the judges have, I feel, come to trust me, and we have a designee system, as you know, in our circuit, where the chief judge has a designate who signs off on all these things, and that is became a 2-year position. I think probably because no judge wanted to sign up for it for life. But I do have always wondered about why does the circuit need to sign off on it? Did Congress not trust the district court judges? I don't know what the reasoning was there, but the judge who's familiar with the case should have the most input into the case. That being said, I would say, and in my opinion, the Sixth Circuit has a very low rate of voucher cutting. I can't speak to vouchers that are below the cap that are cut because they never cross my desk. But without keeping exact standard, just anecdotally and what I've seen cross my desk, I would say that district court vouchers in the Sixth Circuit that probably less than 1% are reduced. And honestly, the ones I've seen probably should have been reduced. Judge Moskowitz talked about some of the things in the ECF, the .1s, and we got that word out as soon as we could, and our panel members have been very good about following that sort of thing. That being said, I don't wear rose-colored glasses. Every attorney on the CJA panel in the circuit is not a saint. There is a little padding that goes on sometimes. One of the advantages to being in my position over these 9 years is that I know that there are certain attorneys I need to scrutinize their vouchers more closely. By the same token, I also know that there are some judges in the districts that will sign any voucher that's put in front of them, and I have to scrutinize those vouchers a little more closely too. But on the whole, I think our panel members are excellent. I think our judges are excellent. But as far as just the actual requirement of the circuit having to sign off on everything, sometimes it drives me crazy that the low rate of service providers with $2,400, $2,500, then it has to come to the circuit. That rate is ridiculous. You can't get much done for $2,400 or $2,500. And again, why should the district court judge who has the case in front of them not be the one to make a decision as to whether they should get that money for an investigator or an expert?
Could you speak into the microphone? Thank you.
I'm sorry. I received an email from Circuit Judge Lynch, who sits in the Second Circuit, just a couple days ago, asking me, do I really have to put a second signature on a $2.70 voucher? Someone needed a transcript of an adjournment. And so, but that had, because of the previous vouchers that had been submitted, he had to spend his time signing a $2.70 voucher. It's, in my view, ridiculous. When I applied for this program, or when I started working on the program, Bob and I, Bob will, I'm sure, agree with me, we were given the equivalent of 3 sheets of paper and said, go out there and do this job. So we went out there and we talked a great deal about what are we going to do? How do we do this? And we came to the conclusion that the job will be what the court needs it to be. And what the court needed was help with vouchers. Again, preparing for my interviewing for this job, I read a report that had been done 10 years earlier on the CJA Administrative Attorney pilot program that had preceded the case budgeting program for by about 10 years. And one of the conclusions of that report was that the lawyers will do whatever you ask them to do as long as you pay them promptly. And I've been guided by that throughout my entire career as the case budgeting attorney. When I started in this job, the circuit was 6 months behind in paying their vouchers in my circuit, and in Bob's circuit, they were 2 years behind in paying vouchers. And the first thing we did was get involved in the voucher process to expedite the signing of the vouchers. And what that meant in my circuit was that I had to review every excess compensation voucher that came to the circuit for a second signature, and I put a little comment on it, many times just a few words, something as simple as reasonable for an appellate brief. The judge would read those. I don't know whether the judge went through every page of the voucher thereafter, but my guess is that they didn't. And they relied on me because I came to the job with 28 years' experience as a CJA attorney. I had done the practice, and I was familiar with it. And to this day, I just had a conversation with another judge on the Court of Appeals the other day when I trained her in the e-voucher system. And she said to me, our goal is to get these things out of here as quickly as possible, to spend as little time as possible on the vouchers. This is not their priority. Their priority is decision-making on the case, not in deciding the compensation. So this is a burden that they don't welcome. And candidly, I think I had a major event the other day. My anniversary is in 3 days. I will be starting my 10th year. I just had my first budget rejected. I've had one in 9 full years of practicing doing this. I have never had a budget rejected until just the other day. And I expected that budget to be rejected because I met with the lawyers. I met with the lead lawyer first. I wasn't satisfied with the way that meeting went. I then had a second meeting with all of the lawyers on the case, because in that case, there are 3 lawyers assigned to that case because of the size of the material, the discovery material in that case. And I pressed them as hard as I could to change their figures, but I have no authority to tell them you can't have this. I can make recommendations. I can talk to them and say, I don't think the circuit is going to approve this, or the district court is going to approve it. I can tell them that, but if they don't want to, this is what they say they need, well, then it goes to the judge and they can argue it to the judge. But, so what does that mean? It means that I have been making recommendations that have been on budgets that have been almost uniformly accepted. I have been making recommendations on vouchers as if I could sign them. To have the circuit judge repeat that is, to me, a waste of his time and maybe even a waste of mine. Because, candidly, the review of those vouchers take an inordinately large amount of my daily work product. And I could do a lot more, and I think, a lot of other things. Maybe I'm being, well, in any event, there's a lot of things that I could spend time doing. For example, I could put together a manual about CJA matters for our judges, because they don't get it anywhere else. So I don't think that there's anything magic about the Court of Appeals judges signing. I don't think there's even anything magic about the district court judges signing. Peter Shaw, he signs vouchers in non-excess compensation situations. I would like to see that expanded. I don't see why our judges should have to spend their valuable time, doing these kinds of things. So that's, I'll try to keep it as...
That's fine. Ms. Weiss, I'd ask sort of a similar question on the district level, and that is, again, understanding that there's a statutory requirement that at the end of the day the judge has to sign off on the voucher, but given the role that you play in the system, do you feel like that someone occupying your type of position could just as easily fulfill that function? And specifically, if you could address the issue which is primarily the one that's raised by advocates of that position who say, well, the district judge knows everything that happened in the case and they're uniquely positioned to be able to assess the reasonableness of the voucher. I was asking Ms. Weiss, but Jerry, you can speak to it too.
Well, they're only uniquely positioned in that limited way, that they are familiar with what went on in the courtroom and what paperwork came to the courtroom. I often think that they have little or no idea what a CJA lawyer does with 90% of his time. If they have never represented a criminal client, then they don't have any idea how difficult some of our clients can be. They don't understand how limited their education is, or their background, their IQ, their ability to express themselves, their ability to process information when given to them. I often see in support documents that come in support of a voucher statements to the effect that my client was of a limited ability to comprehend what I was trying to tell him, and I had to go see him on numerous occasions and repeat what I told them previously over and over again, because the client could not retain the information that I had given to him earlier. Well, unless you've been there and done that, you don't really understand how difficult that is and how time-consuming it is. And if anyone has been to the jail, as many times as I've been to the jail, people ask me when I took this job, you're going to give up practicing and you're going to take this? And I said, my goal is to never go to the MDC again.
Ms. Weiss?
Well, I shared a similar goal to Jerry when I took this job, which was I never have to go to the jail again. With respect to, I actually agree quite a lot with what he had to say regarding whether or not the district judge really knows the case, because much of the practice does go on not in the courtroom and not with the papers that are submitted, but rather reviewing the voluminous discovery that is now being produced, negotiating with the other side, as well as meeting with the clients. And in federal court, as you know, the sentences are so harsh that you really do have to spend quite a bit of time with the clients to explain to them everything that's going on in the case, as well as, you know, what's going on in sentencing, and the pleas are different, and a lot of these folks come from state court or have not been in the system, and it's quite shocking to them. So I do think that somebody in my position who actually has done the work, so I know what it takes to draft a stipulation or review discovery. I require folks to tell me, what kind of discovery did you review? Because we all know you can review photographs a lot faster than you can review a DEA 6 or an FBI 302. That being said, it takes a lot longer than 50 pages. You know, you can't do it in 50 pages an hour, even though that's what's required now for our benchmark, because a lot of work goes into representing these folks. So I do feel that I am in that unique position to evaluate the reasonableness. I don't think that the district judges necessarily have that same experience. I don't even know, I think we have one judge who was a criminal practitioner on our bench. So I think it makes more sense to have that intermediary person to review the vouchers and to determine the reasonableness.
You know, when you talk about sort of that alternative system, and something that Jerry talked about, I think you may have also mentioned as well in your written submissions, one of the, I guess, counter arguments or criticisms of a proposal that moves that function from the judges to some other individual, whether it be a supervisory attorney or a case budgeting attorney or some other functionary. The criticism I've heard often, going back actually to the Prado hearings, is, well, that's creating a whole new bureaucracy. Can anybody address that issue and sort of try to talk about how you feel like that is or is not creating a new bureaucracy, and whether it matters or not?
I don't think that does, in fact, create another level of bureaucracy. In fact, my experience is bureaucracies are difficult to access. And in my position, I think the lawyers have a lot more access to me than they would to a district court judge. My phone rings constantly. I have an open door policy, and I also answer my phone when it rings. So I spend a lot of my time on the phone talking to folks about their requests and what they need and their cases and what do I think might be reasonable, what would fly. So I don't think it's another level of bureaucracy. I actually think it's cleaner.
And I know through the FJC report and other activities of the case budgeting attorneys, that greater interaction that you're describing is something that's resulted in significant cost savings. And do you see that in your position as well? And if you do, is that something that you are able to capture in any meaningful way in your district, the way that interaction leads to cost savings for the defense function?
Well, I think it leads to cost savings in the sense of I could have those, especially with respect to funding, I could have those real honest discussions with folks about, so what do you need? Can we do this in stages? Without them getting their hackles up that they're not getting and they're not going to get what they need. And many times I say, just, we'll give you, 50 hours for your paralegal and then come back. Let's do it in smaller chunks, and people are really receptive to that. So I do think it is a cost savings, and I think it's also an incredible savings of judicial resources, because our judges are super busy. We have a big docket here, and the last thing they need on top of it is to be, reviewing vouchers and, having to deal with lawyers over their funding issues. This way they get the information. I talk to the lawyers, and on the requests for funding that I don't have delegation of authority for, I write usually an email to the judge and explain to them, this is the case, I've talked to the lawyer, this is what they want, this is why they need it, this is what I think is reasonable, and I write up the order, and if you agree, fine, just press the button, and if not, let's talk about it, and I've had very little conversations about it.
Last question I just wanted to ask to Ms. Fox and Mr. Rands and Mr. Tritz, all because you have experience in multiple districts across your circuits that you work in. And it's the same question I asked Judge Moskowitz, and that is, to the extent you know how panel selection works in the districts within your circuits, do you see any correlation between the sophistication or the manner in which panel attorneys are initially selected and retained on the panel on the front end to back end consequences regarding voucher reductions or seeking experts or approval of experts, or just any correlation whatsoever?
I don't know that I've been on this job for less than 2 years, and frankly, I'm still getting to know the cultures of our districts. We have probably the greatest variety of approaches in our circuit, from everything being managed by the Federal Public Defender's Office to nothing being managed by the Federal Public Defender's Office. So I'm afraid, I apologize, I don't really have that depth of experience that I could comment on it, but I know these two do.
I don't. I am not involved in the panel selection process at all in the circuit or in any of the districts, although part of our job is doing training seminars in the various districts. I think that has had an effect on the attorneys. From anecdotal knowledge, it seems that most of the districts do a good job in panel selection and are willing to recognize if a panel attorney is not doing the job that he or she should be doing, that they should be taken off the panel. On the appellate panel, I can tell you that I've spoken with some of the people in the circuit who are involved with the panel and given them my feelings about whether or not an attorney should be on the appellate panel or not. Some of that, I have literally, in reviewing excess comp vouchers, I've read some appellate briefs that I think a 7th grader could have written better, quite frankly. And although I don't know how much of that goes back to, I would have to agree with Peter that I was a trial attorney. I never wanted to do appeals. I think it's two separate fields. It's two separate specialties, and I've always had a problem with the guidelines saying that the trial attorney should stay on the appeal. I don't think that's a wise decision.
I wonder if I might just address your excellent questions. In terms of
Sorry, I didn't mean to leave you out.
I've been chomping at the bit here. They're great questions, and I have some thoughts on those. First, about the second level approval by a circuit, by the chief judge or delegate. I've worked with many circuit judges now who've been in that role, because in our circuit we delegate them to 3 judges rather than, none of them feel well equipped to do that. They don't, and I think just objectively from a management standpoint, it seems irrational to give that kind of auditing review to people kind of at the top of the management level who don't have any prior experience or insight into the details of the case. And to ask them to do the kind of review that you're asking seems not cost effective. It just doesn't seem like something that would be done in any kind of a rational organization. Where there is a uniform voucher approver, I think you solve a lot of the problems, because the one thing that you can do that way is to look at the outlier judge who rubber stamps. But even then, allocating the high-level circuit judge to do that doesn't seem to me to be a rational approach. I think I can freely say to you that the unanimous view of the judges who've played that role in our circuit is that they don't want to do it and they don't see the rationality and they don't even know what they're supposed to be doing. About panel selection, you asked both Judge Moskowitz and us the question of whether panel selection at the outset in terms of trying to get high-quality practitioners yields cost savings at the end. And I don't think that's true. What I think it does do is get you high-quality attorneys. And the way I deal with that issue is when I have a new attorney on a panel, I will give strict scrutiny to the first few vouchers and get a sense of whether that attorney has a good idea of what's reasonable in terms of expenditures. So I think that, at least from my standpoint, the way I can accomplish the goal of efficiency and cost savings is in early intervention if there seems to be a high number of hours for tasks. And so I'll address that right at the outset, and then they'll get an idea of what's expected from the court. But I don't think there really is a correlation between quality and cost efficiency. I think sometimes there's a negative correlation there. When you have people who really put the time in to do high-quality work, sometimes they spend more hours than somebody who doesn't do high-quality work. Thanks.
To answer your question, I think there's a direct correlation between the quality of the lawyer put on the panel and the cost of his work. Because in my view, a good lawyer is not necessarily only a good lawyer. He's also a good businessman. And that means that he bills us for everything he's entitled to bill. I've noticed that among our CJA panel, we get a benefit by the poor record keeping of many of our practitioners. I'll see vouchers, there's no travel time in the voucher. Nah, I don't bother billing for that. There are many areas where they just don't keep the records. It's too much bother to put down every phone call, so I'm not going to bill. I don't bill for that. I don't bill for that. It's very common. Well, the organized, excellent lawyer, he bills for everything. He'll bill for the token to get on the subway. He'll bill, of course, he's entitled to it. And I don't hold that against him when his bill comes in. It's a cost of doing business. You want a quality person, you may have to pay a little extra for it. Not because he's not doing the work, or maybe not because he's not doing what he should be doing, it's because he's charging us for everything that he's entitled to charge us. So I personally believe, some of my best lawyers on my panel, lawyers who I would put up against any lawyer in the United States. That's how good these people are. They're also my most expensive because they keep good records. They know what the rules are, they know what they're entitled to receive, and they ask for it. And we pay it. So I think there's a direct correlation. The better the lawyer, it may in fact be the more it's going to cost us.
Judge Gerard.
Thank you.
All right, and I am going to, so that everybody gets a chance, I'm going to kind of hold everybody's, particularly
What do you want, one or two questions?
No, you go ahead.
Okay, I want to talk to Mr. Shaw to give voice to an area that we haven't talked a lot about, and that's appellate representation, the continuity of representation rule that you discussed. In my former life, I was an appellate judge, so I would agree with you in many ways that appellate specialists are very necessary. However, they are not always available in many areas of the country. Certainly on this coast, on both coasts, they're available. In between the coasts, not as much. And what I want to talk to you about is a systemic issue, and that is how do we attack that issue within the purview of this committee's charge? In other words, how do we give voice to that? How do we, as a practical matter, what do we do as a committee? What suggestions would you have?
In terms of trying to recruit appellate specialists in areas where they're rare.
Recruit, train, and whether that in fact should be a recommendation of ours.
Well, you can try and do as much as you can in working with what is available to you in the geographical area that you have. One thing that has occurred to me in our circuit, where we have had this tradition of getting attorneys from the district where a case arose, is that premise is not necessarily reasonable any longer. It used to be that you'd want an attorney close to where the district court was, so that attorney could go look at the records and be close to that process. But now, where so much of the work is available electronically, and where the clients are dispersed based upon the decisions of the Bureau of Prisons, outside the purview of the judiciary even, it's no longer necessarily the case that the attorney will be close at all to where the client is institutionalized. So the traditional reasons why we have had attorneys close to the district court no longer pertain. So I would say that there's no reason why a court could not expand its search for appellate attorneys outside the ordinary purview of what it had done traditionally and look for people. In our own circuit, we have a wide disparity of appellate specialist availability. So now what I see is the District of Alaska, where there are a few appellate specialists, is now using attorneys from this Central District of California 1,000 miles away, and attorneys who are proven good attorneys may be on several different panels, especially in areas where there aren't some. So to the extent that the court is willing to explore that opportunity, I think that's the most likely solution.
Okay, very well. And yes, Mr. Tritz.
I'd just like to make the point that appellate practice, as opposed to practice in the district court, one of the main differences is that there is not as much client contact necessary. So it's easier for a lawyer who may be in the in the Northern District of California to handle a case from Whitefish, Montana, because maybe he has to make 1 or 2 trips to visit with the client to discuss the issues, but that's it. Otherwise, he's got the record. He can work at his office. The fact that he's distant in mileage, it doesn't really affect the quality of his representation. So the fact that in certain districts there may not be as many appellate lawyers shouldn't mean that we can't make use of appellate specialists for that reason.
Right. Yeah, there's some cultural things to overcome, but my question was, as a practical matter, to be utilizing that, and that's very helpful. Ms. Weiss, I did want to ask you, certainly in your district, you're doing the reasonableness review on vouchers and other service providers, and one of the things that we've heard in some areas is, well, that's okay for you. That's what we do in the Midwest. That's what you do. My colleague to my right does that. But in some areas, it's just not practical. The districts are too large. They're too big. What do you do in? Obviously, you are from a large district, and how do you handle the circumstances?
I'm sorry, I don't really understand.
Okay, the
what
question,
you're asking.
I'm sorry, I didn't ask a good question. That is, for example, you are doing, as the CJA supervising attorney, you're doing initial reasonableness reviews, is that correct? For your judges, you're doing reviews for other service providers, et cetera?
Yes.
Okay. There are some districts that are large districts that would say to have a CJA supervising attorney or somebody in that position, it's not practical to do so.
Well, we do have a large district here, and it is a fair amount of work, but it's not unwieldy. My suggestion would be, then get 2 of me, because
And that's my
yes,
my question.
I really do think it's a great solution to the problem, and it also ensures uniformity of voucher review, because if I'm reviewing all the vouchers, or there's 2 of us, then you know, the lawyers know what to expect and what to put down in their vouchers, and they're treated the same no matter who the judge is. And I think that goes a long way for both the court as well as the panel.
Can I follow that up with a clarification? Because you actually work for the courts, right? You're
I
employed
do.
by the courts and you're paid by the courts.
Correct. I'm a employee of the clerk's office. Our district court judges made a decision, I think, in 2000 that they were going to fund this position.
But you're aware that there are people that do similar work to you, but they're actually paid employees of the FPD's office, walled off from the federal public defender or from a CDO. They work under a different structure. Is that correct?
I do understand that, and I'm not sure in reality what the difference is in what we do on a day-to-day basis. I can tell you that some of the federal defenders and alternate defender offices have a genuine concern about funding of this position, so I'll leave it at that.
Okay.
Ms. Rowe, do you have a follow-up on that?
Ms. Weiss, I just wanted to ask you a question. My understanding, at least from what I could tell from your materials and your testimony, is that you have a somewhat different position than the folks out of the federal defender offices because you have authority to authorize investigators, interpreters, paralegals. Is that correct?
That is correct.
And I'm not quite clear on your voucher authority. I know that you do a reasonableness review, and that if you do a cut over $450, you give the attorney the opportunity to have a conversation with you. Is that fair to say?
That is basically correct, but any reduction, even if it's a 0.1, gets sent back to the lawyer, and I ask for clarification or justification for any type of reduction. Over $450, if they come back to me with clarification and it continues, and I still say, you know, this still is unreasonable, which very rarely happens, then they have an opportunity to go to a fee review committee to contest those reductions if it's over $450.
So just so I'm clear, so are you the final decision maker on those issues? On the vouchers?
Yes, it does not go to the judges, if that's what you mean, yes.
Okay. So for excess compensation vouchers, you also do the review and make a decision. Do those go to the judges before, to the district court, before they go to the Court of Appeals, or they just go directly to the Court of Appeals?
They go directly to the Court of Appeals. Our judges have great faith in this position, and myself, as well as the folks who have had this position before me, the two women who have had it before me were both federal criminal practitioners.
Let me ask you a question, unless, did you want to go back? Okay. I wanted to ask you a question about some of the materials you submitted, specifically the confidential case evaluation. When I was reading that document, I was somewhat surprised by the information that would go to the judge. And it was my understanding that this information goes to the judge while the case is pending.
Yes, we require that the lawyers fill out the confidential case evaluation initially when they submit their budgets.
And I wanted to, I don't know if you have it in front of you, but it doesn't matter because I'm sure you know it very well. Question number 5 says, describe efforts to settle this case, if any. And that's information that the attorney is expected to provide to the judge during the course of the litigation?
Yes.
Was there any, have the attorneys ever expressed any concern about that?
No, actually, they haven't, and most of the time, it's done in the beginning of the case, and so, you know, so folks don't have, there either hasn't been any because they haven't reviewed the discovery properly, or they can talk about how unreasonable the U.S. attorney is being as well. So the court understands, I need to litigate these issues because the other side isn't moving, or they're giving me an unreasonable offer. Nobody has nobody, to me, has voiced a concern about providing that type of information. And I actually think sometimes it's good for the court to know those things, so they don't always think that the defense lawyers are being totally unreasonable, and why aren't you settling? This is a dead bang loser.
But just to be clear, are they putting in information such as, I mean, obviously you've probably had many, many clients who are just completely unreasonable or half crazy. No matter what you say to them, they won't settle the case. Are they putting things like that in there? Are they talking about their clients and why their clients aren't settling the case?
No, I haven't had that. It only really refers to what's going on with the other side. I haven't had any instances where people have talked about how the client is being unreasonable. I have to say there has been an uptick in our district, I think because of the book that's floating around the jail called Busted by the Feds, where folks are either wanting to represent themselves or they are insisting on going to trial no matter what. And the judges are kind of aware of that, and they see what's going on. And we have a great bench, and they're not taking it out on clients when it comes to sentencing, if that was your concern.
All right, thank you. Mr. Tritz, I just wanted to ask you a question about the budgeting process that you go through. You send a budget up to the court, and when you send a budget to whatever judge it is that you're dealing with, do you also send some kind of a letter that says, these are my thoughts about it, or do you meet with the judge about it?
No. I must admit this is an area of some concern to me. It would probably be best if there was a memo attached to every budget that went up to a judge explaining all the intricacies of this budget and why I think it's inappropriate or what I think is wrong with it. It might be very well to do that. I don't, and it's merely a matter of time. There's one case budgeting attorney in our circuit, and I wear many hats, and I only have so many hours in the day. So I deal with it more on in a more of a responsive way. If the judge has a question, they're not shy about contacting me. I speak with them on a regular basis, and if they have any questions, I respond to them. But I have found really that the judges have two concerns. Mr. Tritz, are you satisfied with this budget? Do you think it's appropriate? Yes, Your Honor. Okay, I'll sign it. Or the other question is, Mr. Tritz, is the defense lawyer satisfied with this budget? Has he accepted this budget? And if I say it, fine, I'll sign it. They're interested in either, am I satisfied or is the defense lawyer satisfied? And they're more than happy not to get involved in the minutia. That's been my
Are you saying they
experience.
always ask you that question, or those questions? Do they always ask?
No, most don't ask any questions.
Okay.
No questions at all. They see the budget. You know, it's like over the years, I've been doing this now 9 years, going on 10. I have a somewhat of a feel for what a budget should be, let's say in a capital case, a stage 1 budget. What my expectations are in terms of monetary figures, where it should fall out, low end and high end. If it falls within that, I'm somewhat satisfied. But there are instances where the budget requests are double what I would expect in other cases. And that sometimes, many times, is a reflection of the lawyers on the case. Some of our most expensive budgets are produced by our resource counsel when they get involved in cases. And I view that as a reflection of their superior expertise, that they're more familiar with these cases, they are up to date on the most recent developments, the newest experts that could be available to them. In fact, one of the reasons that Bob and I have always fought to attend the Capital Case Conference every year is for no other reason than we want to hear who are the new experts that have been come up with during the past year. A few years ago, it was the future dangerousness person, and then the year before that, it was
Victim outreach. Yeah.
Victim outreach, or life after life. That someone who, Wilbur Rideau, who spent a large portion of his life in jail and then got out of jail, and now he lectures and meets with clients who are being offered a life sentence and talks with them about the wisdom of maybe accepting that rather than facing the possible death penalty by trying the case. So every year those change, and so the number of those increase, so that the Resource Council are sometimes far more expensive because they are bringing in service providers that other lawyers may not yet be aware of.
Let me ask all of you a question, and whoever feels comfortable answering this, and this is a little bit of a follow-up on Judge Cardone's question, and that is one of the reasons, or if not the main reason, that we have the case budgeting attorneys was because the courts were trying to get a handle, if you will, on the costs of some of these cases, and it was a cost containment issue. The court is your boss. You're hired by the court, you work for the court, you're evaluated by the court, you can be fired by the court. And it's, as much as I'm, if you will, in a weird way, attracted to all these different positions and what they can do in the system, that is something that I keep coming back to. And I'd like you to speak as to the issue of how you feel about that. Do you feel pressure? Do you feel that you should reduce a budget, or that maybe it's, even though it's a great, great brief, Mr. Shaw, that you receive, as you said, it was an expert representation, the bill is excessive. And do you see that because it's just out of line with other bills that may not be, the person may not be as good of appellate lawyer? But more directed towards the issue of, do you feel any pressure, inclination to contain costs when you know who it is, who your boss is, and why you were hired in the first place?
I've never felt that pressure. I can say when I interviewed for the job, I told the people interviewing me that I was not interested in becoming a hatchet man or slashing the attorney's payments. I don't think, again, I don't want to speak for everybody, I don't think any of us feel that pressure. I also think that it's, our position was long overdue. And I don't think anybody can deny the fact that we have saved considerable amount of money for the CJA, and some of that was just sort of common sense. Before we started, or at least in my circuit, there was kind of an open federal checkbook. It never occurred to the attorneys to negotiate with service providers or to, and part of this is coming from my own background as a criminal defense attorney. As I talk about in my seminars, criminal defense attorneys didn't play well together. They would never call a co-defendant's counsel in a case and say, hey, can we share this expert? Or how about you do the motion and I'll just join in? I have never from the beginning felt a pressure to, that we have to justify our job by hurting attorneys or slashing costs or that sort of thing. Although I do think that was part of the fallout of our job is that quite a bit of cost were saved.
I'll follow up on that. I definitely don't feel any pressure. And I think as court employees, we have an obligation to provide objective advice to the judges. And I don't want to be a yes person, and I don't want to do whatever it is that the judge is expecting. I want to be forthright with my opinions. And that's why they hired me. They don't need me to tell them what they want to hear. They need to just hear what I think and based on my expertise. And so, and then to follow up on the question that Jerry had talked about, when when I speak with council about putting a budget together, my goal is to get us on the same page so that when a judge gets that budget, it's one that we have already worked out. And so far, I would say 95% of the budgets I've worked on have been like that. And so then when it goes to the judge, I'm literally just sending an email with a very short couple of sentences about council and I, we've worked on this together. I think this is reasonable, and I recommend that it be approved. And so far, they all have been.
I feel absolutely no pressure. I am actually, I guess, an employee of the AO. I work up in the Second Circuit, but if I trace where my money comes from, it comes out of the budget of the administrative office. When I was interviewed, I was asked by the circuit executive in the Second Circuit whether I would be willing to argue with judges about issues relating to budgets, and I said I had no problem with that. That's what I've been doing for the last, 37 years. What I find most interesting is that because I took this job, all of a sudden they listen, when they never seemed to listen for all those years previously. So I don't feel pressure at all. And in fact, recently, I went to see a judge in the Eastern District because it had been reported to me that he had been consistently turning down applications for investigators in cases. And I went to see him planning on having a very difficult conversation. And I explained to him that funding was not an issue because I believe that sequestration has had an impact on our court which will take years to completely dissipate and go away. There are judges who are still trying to balance their perceived problems in the budget on the back of the CJA program. And I think we have to work vigilantly to nip that in the bud and to stop that because it's unnecessary. But nonetheless, there are judges who their approach is not consistent with what we think, meaning those of us who are case budgeting attorneys and who are working with the CJA panel on a regular basis, if they're not approving what seem to be reasonable requests, there are times when we have to go have difficult conversations. Now, that doesn't mean that we're going to prevail on those, but on all those issues. But I do believe it's important to have those conversations. In one of my districts, there was a judge who seemed to be cutting vouchers on a somewhat regular basis, so I suggested that they put together a peer review committee of lawyers and people who are familiar with the cases, and where the judge has a problem with a voucher, let it go to the peer review committee and let the colleagues of the lawyer who had produced the voucher review it and so forth. And they did. They made a recommendation to the judge that he shouldn't cut the voucher and that he should pay it in full. The judge rejected the recommendation and still cut the voucher. Because we put programs in place doesn't mean that they're actually going to work. But I think we have to keep trying.
Before I started, our judges were all over the map with CJA voucher approvals. But I think that they were unanimous in the view that it was important to have a uniform approach. And so I have really felt no pressure in terms of cutting vouchers or paying more than I do. And when I do the first certification on all vouchers, whether they're below or above the statutory maximum amount, and I've probably sent, I'm just guessing, 10,000 over statutory max vouchers to our second level approver judges, the circuit judges who have the delegated responsibility. And I think of those, maybe 5 times I've had a judge come back to me with some question about it, but never any pressure that, oh, you're doing it all wrong or anything like that. And they also see the cases where I've made reductions so that they know that I'm not a rubber stamp, so it's been nice not to have that kind of pressure.
Thank you.
Rucker.
Thank you, Judge Cardone. It's nice to see all of you. A question for the three case budgeting attorneys and for Ms. Weiss. One of the things that we've heard at all of the public hearings is the complaint that there's a disparity in the resources available between the AUSAs, the federal defenders, and the panel attorneys, with the panel attorneys clearly not having as many resources available. Has the budgeting process that you're working on remedied that? And let me start with Ms. Fox.
I would say yes. I mean, that's one of the foremost things in our minds, is that we feel like there is a two-tier system. Bob had already mentioned in his opening remarks the fact that only CJA panels attorneys are the only ones who have to go to the court to ask for permission for anything. And so I do think that the budgeting process, while not necessarily, it doesn't fix everything, and we are still, for example, presumptive hourly rates. We have presumptive hourly rates for our circuit that apply to panel attorneys that I think are too low and that need to go up. And I know that we're going to be hopefully addressing that issue within our own circuit. But it's a step in the right direction. It helps level the playing field at least a little bit, in my opinion.
I would agree with Christine. I think it's done a wonderful job in leveling the playing field. Are there still problems? Yes. For instance, I have districts or towns within districts where some people, they're just not available. There might be one investigator in the whole town. I have paralegals are a problem in quite a few places where, other than the large law firms, there are no independent paralegals out there to be hired. There's no law student to be hired. That's something that we try and work on, but sometimes then we also have new attorneys who are willing to do at a paralegal rate some of that work just to get experience in the field. But I think we've leveled the playing field about as much as we can. I don't think we'll ever, quite frankly, get to the point where we pay what the AUSA pays experts. On the other hand, speaking personally, some of these experts, I think their rates are outlandish. I'm sorry, I have a hard time believing anybody's worth $600 or $700 an hour when their only recommendation is they were a police officer for 20 years or they teach at a university level. Every attorney has a PhD equivalent also. We're certainly not paying the CJA attorneys $600 or $700 an hour, and I'm not sure we ever will, but I think we've done a good job of leveling the playing field. The only issue is still that whereas case budgeting attorneys, we can take away some of that. You don't have to divulge to the judge what your trial strategy is. Tell us, and what you tell us is confidential. But that doesn't happen in cases that aren't budgeted. And I do have concerns in non-budgeted cases that the attorneys still have to go in and justify the use of an investigator to the judge.
The statement you made may be the perception. I don't necessarily agree that it is the reality. Because the people who are complaining that they don't have the resources that the government have no idea what the government actually expended on that case, because the government will never reveal that. And so it's merely speculation. And whenever that comes up, I try to deal with it in two ways. One is that let's not go there, because if they spent less, you wouldn't want me to cut your budget to match theirs. So whether they're spending more or not, let's just leave that alone. And let's talk about what you need to handle your case. And how can I help you get what you need? And that's the way I deal with it. Let's not compare, he's spending more than me. You may not need that much. Let me talk with you about getting what you need, and that's the way I try to deal with it. So in that sense, budgeting has helped, because the question is not what the government is spending, it's what do you need and what are we going to spend, how much is it going to cost us, and can we get it approved? And let's just deal with it on that level.
I think that there's a couple of issues here, just dovetailing on what Jerry said. Although it doesn't matter what the government has spent, we're still working at reacting to what they have spent, because they've conducted all this investigation. They have poll cameras, they have audio, they have cell site data, they have all this information that they're throwing at the defense, and we have to, or the defense lawyers have to figure out a way to process that information and use it and understand it so they could evaluate their case and properly represent their client as is required by the Constitution. So I think that's a real concern. Whether or not it levels the playing field, I think that it allows, at least in our district, folks to get what they need to do a good job and to properly represent their clients. I think that the statutory maximums, the $2,500 statutory maximum for service providers is way too low considering what needs to be done, especially the types of cases that are being prosecuted in our district. We have many multi-defendant. We've had 30 death cases recently in the last few years. We've had lots of multi-defendant cases where we need joint paralegals to enter the stuff into CaseMap. I'm getting a terabyte of data, which I just found out each terabyte is 50 million pages, is real. You need someone to help, sift through that stuff so counsel doesn't have to be spending all that time. I also think the presumptive rates are too low for CJA lawyers. It is sometimes hard to find experts. I know we've taken over a couple of cases recently from the FPDs, and the rates that they pay to the experts, which we now have to pay, is higher than our presumptive rates. And in order to keep continuity with that expert, and to actually conserve costs in the end, we've had to have paid a higher rate. We also have some of the DNA folks are saying, we're not doing it for $150 an hour. We all want $200 an hour. We're boycotting. So I think we have to take a look at that. I know the circuit has. I know I'm on the capital case committee for the Ninth Circuit. I know we've looked at raising those rates that haven't been raised since the late 90s, I believe. It's time.
Any other questions? All right, how about any other? Yes, Judge.
My question's for Mr., is it Treitz or Tritz? Tritz, yes.
Like the Ritz Hotel with a T in front.
Okay.
I've been staying there for a lot of years.
We're not staying there, in case you were wondering. I thought that your general premise was that judges, as far as funding, judges should not be involved. There has to be some independent entity or body. And you listed off, you rattled off a bunch of reasons. I didn't get to write them all down, but you said the presumption is or the perception is. And I just want to first make sure I have your thoughts right. One of the things I did get to write down that you said is that the presumption is that if you go to the judge as a CJA lawyer and complain about funding, voucher cutting, funding investigative sources, the presumption is that that judge will take it out on the defendant at sentencing. Is that, if I understood so second part of my question is, if I understood that correctly, could you please provide us with specific data or information to support that position? Because it's a very troubling statement, if it's true.
I understand what you're saying, and I think you mixed a couple of things.
Okay.
Let me just go back. The CJA lawyer is the only player in the system who has to ask permission. The government doesn't ask permission to retain anyone or to expend money. The defender doesn't have to ask permission. A privately retained lawyer doesn't have to ask permission. The only one who has to ask permission is the CJA lawyer. And in making your argument to the judge that you may have to reveal information. For example, if you go in and you ask for money to retain a person to polygraph your client.
Really sorry to interrupt you, we're really short on time, so let me ask a really quick question. Is it the perception, in your opinion, in your circuit, that if a CJA lawyer asks and annoys a judge over resources, that judge...
Sorry, I didn't hear what you just said.
Yes. Is it the perception in your circuit that if a CJA lawyer goes to a judge for resources and upsets or annoys that judge, that it's possible, or it's your perception, or the perception in your circuit, that judge will take it out on the defendant in sentencing?
No, I'm not saying that.
Okay.
All right, the point I'm getting at is if you go to a judge and you ask for funds to retain a polygraph person, you want to polygraph your client, not because you think it's admissible at trial, but because you want to use it in your negotiations with the government to get a better plea offer, and the offer doesn't improve. Well, the judge may perceive then that, I guess your guy flunked it. So he came to you, he lied to you to get you to get a polygraph. You did the polygraph, he flunked the polygraph, and so what was the benefit of all this other than wasting time and wasting money? That is a possible scenario where the judge, because of the information that was provided to him, could come up with an adverse opinion of your client, and he might possibly take that into consideration. That's what I'm talking about. It's not punishing you for making a service provider request. I don't think that happens at all. You need an investigator, you come in, you ask for an investigator. It's just there are times in specific cases where, for another example, we had a situation where there was somebody who was recorded on only 4 conversations, and the defendant denied it was him on that, recorded on the tape. They got the lawyer found a voice print analyst person who was willing to listen and analyze the tapes to see whether or not it was the client or not. He wanted $7,500 a tape, 4 tapes, $30,000. So I get called, I need $30,000 to do this. So my approach was, let's take it a step at a time. Let's start with 1 tape. But if you spent $30,000 and the client is still, the case is still going, the government has not dismissed the case, they are not convinced that the polygraph didn't show that it wasn't your guy, could not the judge perceive that your client lied to you and forced us to spend $30,000 unnecessarily because he didn't want to come to grips with the fact that it was him on the tape? It might very well happen. So it's a perception on the part of the lawyer that in doing this and making the application, I may have to reveal information that could hurt my client at the end. I don't know that a judge takes many things into consideration when deciding what's an appropriate sentence. And in fact, whether or not the client was remorseful, contrite, accepting responsibility, may be reflected in the conduct I just described to you.
Well, I'm glad I asked, because I thought you said that judges, your perception was judges were taking it out if lawyers asked for resources. But
No.
we're okay.
Not at all.
I'm glad I asked that.
I'm glad we were able to straighten that out.
I have sort of a follow-up to that, because in a lot of places we've been, we repeatedly hear who better to review the vouchers than the judge, because the judge knows the case. The judge knows the work that's been done. The judge knows the difficulties. Who better than the judge? And yet I hear from everyone, and you all work for the courts, but I almost hear from every one of you that, first of all, the work you do is in some ways very independent of the courts. And so why do we need the judges involved? I mean, if it puts the judge in the place of sort of perhaps second guessing or not having the time or not really needing to know these things, or perhaps creating these issues, and you all are able to do it and your judges are happy with it, why should we think that it has to be judge involved? Can anybody answer?
We don't think it's only could be the judge.
And it's not like we want to exclude the judge altogether. I mean, the judge is obviously, as you said, the person who presided over that case and who had the interaction. And so if, for example, we're reviewing a voucher, and there's a question, we can consult with a judge and find out,
But the
tell
judge
us-
would be a resource for you.
Exactly.
Yeah, but I heard a number of you say, or at least one of you say, and I think a couple of you say, but even after all that work, you have judges that say, no, I'm not paying it, okay? So my question is, if in a perfect system where, and what we're trying to do is come up with solutions here, in a perfect system, should the judge, after you've done all this work, is there a need for a judge to review what you are doing? Or what the attorneys have done, or, what the combination has done? How should that work?
If you're referring that to me.
For all of you.
But, okay, so my position is that I don't believe that the judge needs to be involved if the case budgeting attorney or someone in authority who is someone who is familiar with the practice, who practiced criminal law and so forth, I think they're in a much better position. The judge, he sees what happened in the courtroom. He sees the papers, but he doesn't necessarily see a picture beyond that. I'll give you a quick example.
Well, let me ask you a follow-up before you do. So who would you be answerable to?
Well,
If you're going to be budgeting and you're going to be approving vouchers and you're going to be saying, yes, you can spend this, who would be your boss?
I think it has to be an experienced professional person, a lawyer, someone who has practiced in the field and is familiar with the work. And I think that person is in probably a better position than the judge to make these decisions. And the example I'm going to give you will show that. I get an extremely large excess voucher that comes to the circuit. I send it up to, I review it, I make some comments on it that I think this is an extremely large voucher. I have my questions about the reasonableness of it, and I express that to the Court of Appeals judge, who was Judge Lynch. He's the chair of our CJ committee in the circuit. And he says, I think I'm going to ask the district judge what her thoughts were, and so he communicates to the district court judge. The response was, I clerked for the Supreme Court, but I never handled a criminal case. I'm not comfortable making these evaluations. Well, that's a very smart person, but that person doesn't have the experience that someone who has practiced in the field for 28 years and who tried cases and dealt with clients and, has someone, I don't want to say such as me, but a professional lawyer who was in that position to make the decisions. Some judges are very qualified, but not all of them are. It's not a prerequisite. But here, if we hired a person who had to have the experience, then we know it's a qualified person. And the question then is, well, is there one person for the circuit, or do we want a district level? Should there be a
Well,
person?
no, the bigger question is, who should those people work for? I mean, we have 3 branches of the government. We have a defender function. Should that entire process be under the courts? Should it be under some sort of defender function separate from the courts?
See, I'm of the belief, I would prefer to see it separate from the defender function, because I don't think that the defender and the approving person, I don't want to call him the case budgeting attorney, whatever we decide to call that person, I don't think we're necessarily on the same page at all times. I think that there may be places where there is actually a conflict between the CJA lawyer and his position on certain issues and the defender. They may not be on the same page. So I would like to see them separate. I don't see why they have to be linked. I know that in many districts around the country, the defender runs the CJA program. But I think that's a matter of convenience and availability rather than necessarily the best way to do it.
So are you saying they should be under the courts then?
Excuse me?
Under the supervision of the courts?
I have no problem with that. I think, I envision something like a deputy circuit executive. So you work for the court, but you really don't work for the judges. You work for the circuit executive's office. It's more an administrative position than it is a judicial type thing. So, and that's kind of what my position is now. I mean, I see my boss as the circuit executive. She's the person I work under. But I have more contact with the clerk of court on a daily basis than I do with the circuit executive. I mean, I work for the circuit executive, but she doesn't really, if she's not involved in the decision-making process that I engage in, I'm left to do that on my own. So, but I have no problem working for the court, but I think they should be independent.
Up with that?
Sure.
Mr. Tritz, if we follow that model, let's say the attorney disagrees with how you rule, who would he or she appeal to?
I'm glad Dr. Rucker, I'm glad you raised that point, because I don't believe that the decision-making process should not have the opportunity to consult with the court. In other words, there are going to be times when I'm going to see a voucher and I'm going to have difficulty deciding whether or not it's reasonable, whether this work was necessary, whether these service providers were a good idea and productive for the client and worth the money we spent on them and so forth. I would want to be able to go to the judge and consult with him on it. I don't necessarily say the judge should have the last word on it, but I think the judge should always be available for a consultation to get the benefit of his wisdom and judgment and his insight into the case based on the participation that he has had. But I don't necessarily think that the decision-making should be his, because I think that the downside of that outweighs the benefit of him being involved in the decision.
Can you also use the peer committee that you described as a recommendation you made?
I like the peer committee, but the peer committee only works if the court is willing to be guided by the peer committee. And the example that I gave you, it didn't work. So what was the purpose of it?
I think what Judge Cardone asked earlier, if you're doing it at, say, a district court level, then the circuit court level would be maybe the appellate process. But to ask the question like, who would be your boss is almost kind of a chicken and egg thing. You can take that forever. I mean, how far up the food chain do you go with an appellate process on a decision, or who is the ultimate boss? I mean, I guess technically circuit court judges might have the boss of the U.S. Supreme Court. I mean, and you know how clients are. Clients always want to keep going one step up the food chain to appeal their case or to fight their case. I mean, it has to stop somewhere. So if it's a district court level making that decision, then maybe the circuit court under a deputy circuit exec or whatever would be the final decision making. I mean, it can be challenged, but at some point there has to be an end to it.
May I ask permission for something? Bob and Christine and I spoke a lot just yesterday. Because when we prepared to come here, the paperwork that we got only gave us a limited insight into what you would really be interested in hearing from us. And although I wrote in my written remarks about having a professional in charge other than the judiciary, I really didn't expect for that to be greeted very warmly here. And so if you are, in fact, interested in hearing more about this, we would like the opportunity to give a lot more thought to it before we gave you any kind of concrete proposal. And if you would permit us, we would like over the next month or two, because I understand you're going to still be doing these hearings for a while, we would like the opportunity to bring this back to our colleagues and share this with them and talk about what might be a good idea going forward and present that to you in some written fashion. And if you would permit that, we would be happy to do
Well,
that.
and one of the things we're going to tell you at the end, I think there's a misperception that somehow this is it, you don't get to tell us anymore. I think a lot of times in these public hearings, things come up that either you hadn't thought about or that you didn't have an opportunity to address. And one of the things I was going to tell you at the end, feel free to submit anything.
All right,
The
thank you
more
very much.
information we have, the better it'll be. I'm going to ask Judge Walton.
Yeah, I had a brief question. I think what you do is laudable, and it may be the best from a political perspective we can accomplish, because I don't know if Congress is going to totally let us off the hook as much as we may want to be out of the process entirely.
Right.
But if we were to recommend, and if it were adopted, that this would be the model that would be universal throughout the country, how likely would it be that we'd be able to get people like yourselves to be willing to do this?
When I applied for this position, the most common question was, you're going to give up practice? How could you do this? And I give them my joke about not wanting to go to the MDC anymore. Now the question is, how can I get one of those jobs? These are now, it is now realized by the CJA panel generally that first of all, they love our position. They have someone to talk to for the first time in their careers. They don't call judges. I heard Judge Moskowitz talk about his committee meets every Monday. In our circuit, the committees meet far less frequently. And when they do meet, they have very little to talk about because nobody calls a judge and tells them, you hear what happened to me last Thursday in front of you-know-who? And this issue came up. They don't necessarily have their finger on the pulse of what's going on. So that's why I think that, they don't have as much need in their minds to meet because they don't really, see the issues. And so I think there would be no problem in getting people such as myself. I think there are a lot of people who thought I was being crazy when I applied for the job, and now they want to know how to get one.
John?
Question I'd like to ask, and
I'm
this
afraid
is
of
just,
that.
I don't really understand something about the budgeting of attorney hours. I'm a federal defender, executive director, and I approve lots of budgets and lots of expert requests and lots of plans for litigation, and understand, based on my experience, how I do that. But I got to tell you, when I start a case, and I'm looking at the beginning of the case, I don't have a clue how many hours I'm going to put into that case. I mean, I honestly can't tell you, sometimes I predict a case is going to be a bear and it's going to take me, like half of my time for the next 6 months, and it turns out to get resolved in 2 weeks, and another case that I thought was going to be nothing ends up being just the most incredible drain of my time. So how do you, this is for all the budgeting attorneys, how do you budget hours, and how accurate are your budgets for attorney hours, not for experts, for attorney hours, when you start that process?
I thought you were going to ask a
Don't
tough
ask you
question.
a week into the case to predict what you're going to do.
There's a couple answers. Is the attorney hours are like the initial consideration are the service providers, especially at the very beginning of a case. And then budgeting in stages or in phases makes a huge difference, especially at we wouldn't put an attorney hour budget together for at least the first few months of the case for a brand new indicted case.
What I always tell a practitioner is, don't worry about it.
Yeah.
Of course, you can always come back. What's the judge going to say? You need more. You need more interviews and conference time. Well, you spoke with your client enough. You don't have to be with your client anymore. Judge,
but
say that?
There are circuits where that happens.
Well, I think there's times where you see there may be times where a judge tries to say that, and I was asked to go out to one of the circuits in the Midwest somewhere a couple of years ago to speak to a number of chief judges that were having a meeting, and they were concerned about lawyers billing time for going to see their clients in jail too much. And I told them, if that's what you're concerned with, you already lost. You have no chance. Because the lawyers live in the cracks. All the law is opposed to them. The law doesn't help. That's why when you give them a rule, they'd rather discuss the exception to the rule than the rule themselves, because the rule isn't going to help them. If you're going to tell them they can't do this, they'll find another way to do it, and you'll end up paying for it there. The approach is, we're all in this together. I don't mind you going to jail, but when you go, maybe see 2 clients or 3 clients, so you won't have to make additional trips on those other cases. And deal with it that way, rather than trying to tell them he can't go. The hours are, the number of hours they ask for is almost unimportant, because if they need more, they can come back. You need more legal research time? I can't tell you. You went to the library enough. No more library for you. You may hope I say that, but I'm not going to say that. So if you come in low, come back and ask for more.
Mr.
We
Khan?
know it's a best guesstimate.
Just to specifically, logistically, what I do is I say, look at your calendar. How many other cases do you have going on right now? For just the next 3 months, how much time can you actually devote to this case? And that's sort of, we take this practical approach. And so we do break it up into smaller chunks to make it easier. And we don't want it to be an onerous process. I tell them that all the time. And we want this to be as easy but beneficial as possible.
We also budget 6 months at a time. And I think that it gives the lawyers, and they like it because it gives them sort of a game plan that they never had before, had to think about how to manage their case. You know, I have this much discovery, this is basically what I need. The hours are fungible between categories, and I agree with Jerry. If they need more, they get more hours, but we have to, because of e-voucher, we have to set the amount of money that's authorized as their limit in e-voucher. So they can't submit a bill if they haven't submitted a budget. I also think that it just allows the lawyers to conserve resources, to case manage better, which many of our panel lawyers are sole practitioners. They haven't had to think about the long run in how they're actually going to do the case. We're reactionary in many respects, and this allows them to not only do that, but also, as I think someone else mentioned, to pull resources of, let's get a joint, we don't all need to do case map. Let's get a joint paralegal. Who's going to do the poll cameras? Okay, great. So one person will be in charge of getting the 5 paralegals that are going to review the 3,000 hours. So it actually makes a lot more sense from our perspective, and the lawyers, they like it.
Attorney hours is not the area where we have an expectation of conserving costs. Lawyers got to do what a lawyer's got to do. We're more concerned with their service providers. Are they being paid the correct presumptive rate? And did they try to get us the best price? Did they negotiate? Did they shop around? Did they do the things that I listed in my written statement?
May be shared.
Yeah, can they be shared? Attorney hours is, in my view, is not the main focus of what you're concentrating on with the goal of conserving costs.
The main time I mess around with attorney hours is when I get a proposed budget and I call the attorney and say, if you just do the simple math, you've got yourself working on this case over the next 4 months, 60 hours a week. Did you close the rest of your practice, or should we talk about where these hours are coming from?
Thank you.
You'd be surprised at how often that happens. I need 500 hours to review discovery because 500 hours is just a nice round number.
Thank you.
All right, well, on behalf of the, yes, I'm sorry, I apologize, Professor Gold.
Thanks. Last but not least, it's good to see a couple of you again, and the others of you who I don't know, it's nice to meet you as well. This is one question, maybe two, depending on how you all answer it. There's a statement in Mr. Rance's testimony where he says it's been brought to our attention that the use of service providers is very low in some of the 9 districts in the 6th Circuit. And indeed, that is not a concept limited only to the 6th Circuit. That's also true of the 9th. It's also true to a lesser extent in the 2nd. The committee is really trying to get their brains around what's driving this. And collectively, you've given the committee at least 2 possible explanations in both your written and oral testimony. So Mr. Rance says that it is possible that that the culture in some districts is such that the requests are no longer being made, so that in some districts, attorneys aren't asking for service providers. And Mr. Tritz, I'm going to do something that no one ever does, and that's put words in your mouth. One of the other possibilities, I think, if I may paraphrase one of your earlier comments, is that you have a problem judge in at least one of your districts who isn't giving particular kinds of experts or other service providers. What else are the possible explanations for this?
I'm kind of curious where that data is coming from. I have some issues with some of the data that I've seen regarding the funding requests in our circuit, and specifically in our district.
Your district is not one of the ones I'm actually referring
Oh,
to.
shucks.
There's also, and this is across the board, but if you have a case with a shared service provider, it's only getting counted.
I'm sorry.
If you have a case with multiple defendants,
Right.
but it's a shared service provider, only one of those representations is being credited because the bill only goes through one attorney's billing. So I'm not sure how much of that impacts the statistics that you have.
You're at the margins still. That doesn't describe tremendous disparities. Are there other things that the committee should be thinking of?
I think in some cases, and this harkens back to my own experiences, I mean, if I get a case, or got a case in the past, and went in and saw my client, and my client says, yeah, I did it, get me the best deal you can, I wouldn't go out and ask for an investigator. It's like...
And I was going to follow that up, because we did ask attorneys in one of the districts in our circuit that is on the very low side, and we were told by the attorneys, our U.S. attorneys give us good deals right out of the gate. They have a fast-track type of process.
And it's in the federal system.
And there's really no reason to spend money on something when we already know where we're going with this case.
Those of us, the state system always knew. In the federal system, you know, they tend to spend so much time investigating that case before they ever even issue an indictment. You don't have a whole lot of chance of winning in the federal system, which is why there's so few trials, I think. It doesn't mean that everybody's guilty, but if you do the stats on how many people are found not guilty, I think it'd be a very large percentage. So we recommend and tell all our people at our seminars, if you need an investigator or a service provider, ask for it, but we're not out there saying you have to ask for an investigator in every case, because it's still the attorney's decision.
I know you don't have a problem with our district, but one remedy I did think of for those folks who are concerned about asking for funding is to raise that $800 that you can get without having to ask the judge, because you can't do much for $800. Maybe you could have your interpreter go a couple of times to the jail with you, but other than that, that number really needs to be raised, especially for those districts that are having trouble getting the funding.
Final 2 points I'll make on this are that I have had conversations with especially sole practitioners who are not used to working with, let's say, a paralegal or an investigator on a regular basis. They prefer to do the work themselves. They're going to do their own witness interviews. They're going to do their own tracking down, investigating an informant, and they want to do it themselves. And then the second is just left my brain. I had it in my head. I just forgot it. Jerry?
Well, it comes back.
It'll come back.
I cannot think of anything that this committee could do that would increase the use of service providers by our CJA panel.
Nothing.
I cannot think of something that you could do. I think that it is a reflection of the lawyer's style of practice. I don't know that I may not be putting myself in the best light by admitting this, but when I was practicing as a CJA lawyer, I didn't make as much use of investigators and service providers as maybe I could have. And I think of it as that I had a much more pragmatic approach. I look at a case, I evaluate the case, I see this is a plea, my client says, no way, I'm going to trial. I understand, that's his position today, but as he learns more about what the evidence is, I mean, that's why we have things like reverse proffers, so that the defendant can be confronted with the evidence against him, and it's a little easier for him to make a decision to dispose of the case. I think lawyers know where the case is going much before their client does, and they realize that maybe isn't necessary to start interviewing every possible witness that that we could think of. The case is going to be disposed of. It's just a matter of time it's going to take to bring the client to that realization.
So on that point, and I apologize for keeping us from lunch, Are you also saying that the level of representation, quality of representation, is the same between the panel and between your public defenders?
Are you asking me?
I'm talking to you.
I think that I know that the statistics don't necessarily back that up, but I think beyond question that they are on par. I think the statistics are skewed by the cases that, for example, we have a district that has an airport, so they get every mule case. Well, they get good dispositions on those mule cases because there are knockdowns on those left and right to dispose of those cases. So if the defender gets, if you look at the statistics of how many good deals did the defender get as opposed to the CJA lawyer who doesn't get the mule cases, we get a lot more convictions without such good deals. I don't necessarily think, and I'm saying this to a statistician, I don't necessarily believe that the statistics actually reflect the quality of the representation. I know of no panel members who plead cases out just to get rid of them, who throw a client to the dogs, who don't try. You don't stay on the panel very long if that's your approach, especially under our present leadership of David Patton, who was our new federal defender in the Southern Eastern Districts, doing a very good job. But that would be my answer.
Any of the rest of you want to weigh in on that?
The second thought I had was it's a training issue. I mean,
A training issue?
for a lot of these as CJA attorneys.
Did I miss anybody? Okay, thank you very much. Again, I want to encourage you, if you have a follow-up, do not hesitate to contact the staff. Again, we have the cjstudy.fd.org. You can certainly submit it through there. You've all dealt with our staff, and you can submit it through our staff. We appreciate your time. We may have questions for you that we may follow up with, but in the meantime, thank you.
Thank you.
All right, we stand adjourned, and we will be back starting again at 2:15.